as a part of the course on insolvency and bankruptcy law in India. Today we are going to discuss on the topic initiation of CRP by the operational creditor. In the last class we have discussed who is considered to be operational creditor and what is considered to be operational debt. In the last class we have discussed. Okay, so today we are going to discuss operational creditor, how he can make an application under IBC. So the procedure for insolvency resolution by operational creditor is laid down under section 8 of the Act. Okay, so if you observe the provision under section 7, section 7 speaks about the procedure for initiation of insolvency proceedings by the financial creditor. Section 8 speaks about the procedure for initiation of insolvency proceedings by the operational creditor. So both are different. Okay, so we will discuss it subsequently. What is the difference? First, let us complete section 8, then subsequent other interpretation. Then subsequently, we will discuss how the position of operational creditor is different from the position of financial creditor under the legislation. Okay. So, section 8 is the Magna Carta, which provides the entire procedure relating to initiation of insolvency proceedings by the operational creditor. So, if you observe section 8, an operational creditor may, on the occurrence of default. So what is important? Default. There should be some default. Deliver a demand notice. You are supposed to deliver the demand notice of unpaid operational debt or copy of an invoice demanding payment. So either you have to send the notice or else you have to send the invoice demanding the payment of the amount involved in the default to the corporate debtor. To whom we have to send? To the corporate debtor in such form as may be prescribed. Okay, so today we are going to see the format also. Okay, how we are going to send the notice. Okay, what is the format that should be used? Everything we are going to discuss today. Okay. Then the corporate debtor shall within a period of 10 days. So what is required? Once if you send the demand notice or invoice demanding the payment, the corporate debtor within a period of 10 days from the date of receipt of demand notice or copy of invoice. So the operational creditor, either he can send demand notice or else he can send the invoice. So if he is sending demand notice or invoice, in both the cases, okay, so within 10 days he should make the payment. Okay, so receipt within 10 days, within a period of 10 days of the receipt of demand notice or copy of invoice mentioned, bring to the notice of the operational creditor. Okay, so within 10 days what he is supposed to do? He has to reply. So what he is supposed to reply? In the reply, he may state existence of dispute. Okay, if there is any existence of dispute, then obviously the question of payment of money will not arise. Okay, so until unless the dispute is settled, you are not going to repay the money. Okay, so first you have to raise the point, existence of dispute. If there is any, you have to say that yes, there is a dispute is there, I am not going to pay the money because of this reason. Okay, so if any, or record of the pendency of the suit, if any case is pending or arbitration proceedings are filed before the receipt of such notice or invoice in relation to such dispute, you have to give notice to opposite person. Then the payment of unpaid operational debt. So the operational creditor is asking you to make the payment, then you can make the payment. Okay, so if you have already made the payment, then in such cases, by sending an attested copy of record of electronic transfer. So you must be having some evidence, okay, where you must have transferred the money through bank transfer, NEFT, RTGS, whatever it is. Okay, so through bank transfer you must have transferred. So please have the receipt. Okay, so by sending the attested copy of record of electronic transfer. So you are supposed to send the information to opposite person stating that boss, I have paid the money on so and so date. So this is the transaction receipt, etc., etc. You have to give the information. Okay. Then by sending an attested copy of record that the operational creditor has encashed a check issued by the corporate debtor. Maybe the corporate debtor must have issued some check to the opposite person. Okay, he must have encashed. So you must be having some data from the banking institution stating that so and so check with number so and so has been encashed. So send the attested copy of the record that the operational creditor has encashed the check. Then for the purpose of this section, what is the meaning of demand notice? Okay, demand notice means a notice served by the operational creditor to the corporate debtor demanding payment of the operational debt in respect of which the default has occurred. So what is the meaning of demand notice? Demand notice means under this act, the operational debtor is supposed to send notice to the corporate debtor Okay, so the notice that is sent is called as demand notice. Okay, then under section 9, which is speaking about the application for initiation of corporate insolvency process by the operational debtor. So how to initiate? Application by the operational creditor. So you are supposed to make an application to the NCLT. So after expiry of the 10 days. So in the previous section we have discussed 10 days he has to give the reply, either stating that there is a dispute is there, or else either stating that the money is already encashed, I have paid the money. Okay. So after expiry of 10 days from the date of delivery of notice or invoice, demand in the payment, if the operational creditor does not receive the payment from the corporate debtor or notice of the dispute. So either the corporate debtor has to receive the payment or else notice stating that I have made the payment. Okay. Or else there is a dispute is there. Then the operational creditor may file an application before the adjudicating authority. So there are prescribed formats are there. We are going to discuss formats. So in the prescribed format, the operational creditor has to make an application before the adjudicating authority. Okay. Then the operational creditor shall, along with the application, so what to be submitted? A copy of the invoice demanding payment or demand notice delivered by the operational creditor to the corporate debtor. Already he must have issued the demand notice to the corporate debtor. So that copy of the invoice demanding payment or demand notice, whatever it is, so you are supposed to give it to you are supposed to submit along with the application. Okay. Then an affidavit to the effect that there is no notice given by the corporate debtor relating to the dispute of the unpaid operational debt. Okay. So maybe you had to give an affidavit stating that there is no notice given by the corporate debtor relating to the dispute. Okay. Then a copy of the certificate from the financial institution. So these are all the various attachments described under the legislation. Okay. So certificate from the financial institution maintaining the accounts of the corporation creditor, confirming that no payment of the unpaid operational debt by the corp if available. So you may give, as a operational creditor, you may give the bank statement stating that I have not received any money from the corporate debtor. Okay, you can give a certified copy. Then a copy of any record with information utility confirming that there is no payment of unpaid operational debt by the corporate debtor if available. So if any information is available with the information utility, then you can give such information stating that so and so person is liable to pay, the corporate debtor is liable to pay to so and so person so and so amount, particular amount. Okay. Then any other proof confirming that there is no payment of unpaid operation debt by the corporate debtor or such other information as may be prescribed. Okay, so if you are having any other information stating that I have not received the payment, then in such cases, these other proofs can be submitted along with the application. Okay. Then an operational creditor initiating the CIRP under this section may propose resolution professional to act as an interim resolution professional. So here you have to understand, in the previous sessions, when we are discussing about the initiation of CIRP process by the financial creditor, when he is making an application, he shall give the name of the resolution professional. That is, he shall propose IRP, interim resolution professional, who is going to take care of the management of the company as a resolution professional. So referring interim resolution professional is mandatory in case of financial creditor. But whereas in case of operational creditor, the word used under the section is may. He may propose a resolution professional. So it is not mandatory in case of operational creditor. Okay. Then once the application is made, what adjudicating authority shall do? The adjudicating authority shall, within 14 days from the date of receipt of the application, okay, admit the application and communicate such decision to the operational creditor. He may admit the application and stating that yes, we have admitted. So case number so and so, he has to give the details. Okay. Then if the application, when he is supposed to admit, if the application made is complete, there is no payment of unpaid operational debt. The notice for payment has delivered by the operational creditor to the corporate debtor. No notice of dispute has been received by the operational creditor. Okay. These conditions must be satisfied. Okay. There is no disciplinary proceedings against the resolution professional. So when adjudicating authority shall accept the application, okay, the application is full. It should be complete. Then no payment is received by the corporate debtor from the operational debtor. No payment is received by the operational debtor from the corporate debtor. Okay. The notice for payment has been delivered by the operational debtor to the corporate debtor. Okay. Then there is no notice of dispute. Dispute is also not raised. And no disciplinary proceedings against the interim resolution professional IRP. Then if these conditions are satisfied, then adjudicating authority may accept the application. He shall reject, okay, the application when the application is made is incomplete, if the application is not complete, and there has been payment for unpaid operational debtor. The corporate debtor has made the payment. Then if he made the payment, then there is no concept of filing an application under this section. Okay. Then the creditor has not delivered notice for payment. So one of the mandatory requirement is that creditor, that is operational creditor, is supposed to deliver the notice of payment. If he fails to deliver the notice for payment, then he cannot file an application under this section. Okay. Then notice of dispute has been received by the OC. So OC has received the notice stating that you are asking me to pay some amount, but there is a dispute is there. Okay, or there is a record of dispute in information utility. Already the record of the dispute has been updated in the information utility. Okay, so in these cases and in other cases, any disciplinary action is pending against the resolution professional. So in these cases, the application can be rejected. So provided that adjudicating authority, before rejecting, he shall give a notice to the applicant to rectify the defects within a period of 7 days. So he shall give the notice of 7 days. So after 7 days also, if the operational creditor is unable to rectify, then only you can reject the application. Okay, now let us try to discuss in detail. Section part where how to make an application is given in detail. Okay, now let us discuss about application. Okay, so how to make an application? Form number 3. The operational creditor, he is expected to make an application in form number 3. Okay, form number 3 is talking about form of demand notice or invoice demanding payment under the IBC. Okay, so it is not necessary to attach any other document. Form number 3 will be more than sufficient. Now let us look at the form number 3, how it is. This is form number 3. Okay, so form number 3 of the rules: form of demand notice or invoice demanding payment under the Insolvency and Bankruptcy Code 2016. So what we are asking here, date will be there, then address, then name from whom you are from address and to address, and these are all the particulars of the operational data. Total amount of debt, details of transaction on account of which debt fell due, and the date from which such debt fell due. So when it is due, what is the details of transaction? Okay, then amount claimed to be default, how much amount you are claiming it to be default. Okay, and the date on which the default occurred. Okay, when the default has occurred. Particulars of the security held. If you are having any security, then what is the security? Okay, if any. The date of its creation, its estimated value as per the creditor. Attach a copy of certificate of the registration of charge issued by the registrar of company. Suppose take the example, when the company has created any charge on the assets of the company, they must have registered the form, CHD form, with the ROC. So the attached copy of the certificate of the registration issued by the registrar of companies can be given over here. Okay, then details of retention of the title arrangement, if any, in case. Okay, then record of default with the information utility. So if the record is there even with the information utility, please give the information. Okay, then provision of law, contract or other document under which debt has been become due. So under which section, under which legislation the debt is due. So you have to give the provision of the law. Then list of attachments, documents attached to this application in order to prove that existence of operational debt and the amount in default. Okay, so you have to attach the list. Okay, so this is how you are going to make an application. So these are all the various things that you are supposed to give along with the application. If you dispute the existence or amount of unpaid operational debt, please provide the undersigned within 10 days of the receipt of this letter. Okay, then if you believe that debt has been repaid before the receipt of this letter, please demonstrate such repayment. So because you are giving to the corporate debtor, so you are asking the corporate debtor stating that if there is a dispute is there, please state it before. Okay, within 10 days, please give the reply stating that there is a dispute is there. So if you have already deposited the money, then please give me the bank data. Okay, so bank statement where you have deposited the money. Okay, then These are all the various other things to be given. Okay, the undersigned requested to unconditionally repay the unpaid operational debt in default in full within 7 days. So you are asking the corporate debtor to give the payment within 10 days. Okay, within 10 days in full you are requesting him to pay. So in this form, that is form number 3, you are going to make an application. So you are going to give the notice to the corporate debtor. Okay, then form number 4. Okay, form number 4. Okay, form number 4 of notice with which invoice demanding payment is to be attached. So form number 3, I need not to give any invoice. Whereas in case of form number 4, I am supposed to give the invoice. Okay, so form number 4 speaks about, it is about form of notice with which invoice demanding payment is to be done. So when I am having the invoice, I am supposed to give the notice in form number 4. When I don't have any invoice, okay, when I don't have the invoice in the normal circumstances, I am supposed to make an application in, I am supposed to give the notice in form number 3. Okay. Now let us look at the form number 4. So even in form number 4 also to address and from address will be there. Okay, so you are going to give, okay, hereby provides notice for repayment of unpaid amount of INR so and so amount. This is in default as reflected in the invoice. Because you are attaching the invoice, there you can know what is the purpose of claim. Okay, so did you render the services or did you avail the services? Everything will be there. Okay, so in this format you are supposed to make the notice. Okay, then so form number 3, it is the form for demand of notice. Okay, invoice demanding the payment under ABC. When you are having only invoice, okay, form of notice with which invoice demanding the payment is to be attached. Okay, now whether issuance of notice, is it mandatory? What is the significance of issuance of notice? Because whenever if you want to file an application under section 8 and 9, you are supposed to give the notice under section 8. Okay, so that is why it is considered to be, it is sine qua non, that is mandatory. Notice in form number 3 and 4, they are mandatory, please remember. Okay, failure to give 10 days notice as per section 8 subsection 2 would entail the dismissal of application. Okay, so if you fail to give the notice, that is 10 days notice, then the application can be dismissed. Okay, so in the case of Uttam Galva Steel Limited versus DF Darshe Forfeit AG. So in this case, NCLAT, okay, demand notice containing the particulars in form number 3 or form number 4, they are mandatory. So you are supposed to give form number 3 or form number 4, compulsorily has to give the notice. Then in the case of Mobilox Innovations Private Limited, the Supreme Court held that on the occurrence of default, OC is need to deliver demand notice. So that means compulsorily you are supposed to give the notice. Without giving the notice, you cannot proceed further. Okay, so even in the case of Neeraj Kumar Singh versus LI Digital Payments Private Limited, in this case NCLAT, National Computer Law Appellate Tribunal. Okay, so slight deviation from the format can be accepted. So because we are having form number 3 or 4, is it mandatory to follow the forms only? No, it's not mandatory. So if there is any slight deviation is there in the form prescribed format, yes. Okay, so the court is going to observe whether all the essentials are satisfied or not. Okay, so they are not going to verify whether is it as per the form only, exactly as per the form only, is it replica of the form. Generally they don't observe that. Okay, they'll see the content. Okay, then as per regulation 2C of CIRP regulations, the OC while filing an application under section 9, he's having mandatory or he is mandated to furnish the PAN number as well as mail ID. Compulsorily you are supposed to submit the PAN number and mail ID. Then authority of the person issuing the notice, who can issue the notice. So in the case of Uttam Gal Steels Limited versus DF Datshe Forfeit AG, NCLAT held that OC can apply them himself. Okay, who can make an application? OC can apply himself or through a person authorized to act on behalf of operational creditor. So you can give the notice yourself or else you can authorize someone to give the notice. Okay, person authorized must hold position with or in relation to the operational creditor and only such person can apply. Okay, so you cannot authorize everyone. So the person to whom you are authorizing, such person must hold some position. Unless he is having some position, he cannot give the notice. Okay, then once the notice is given, so till now we have discussed how operational creditor can give the notice. Okay, so once the notice is given stating that opposite person is liable to make the payment, okay, then how corporate debtor has to give the reply. The CD may issue a reply within 10 days from the date of receipt of such notice, highlighting the following. So what suppose they are supposed to highlight? Existence of any dispute. So either they can say that there is a dispute is there, we are not entitled, we are not liable to make the payment. Okay. Then the details of any payment already made. If any payment is made already, the details you are supposed to give. Okay. So here when I am talking about the details, maybe you can give the bank statement. Okay. Then what is the meaning of dispute? Because the corporate debtor, okay, can raise the issue stating that there is a dispute is there, I am not liable to make the payment. Then what is the meaning of dispute? The term dispute is defined under section 5 subsection 6. Okay, so dispute can be a suit or arbitration proceedings relating to existence of amount of debt. So there is a possibility there is a dispute as to the existence, whether I am liable to make the payment or not. Okay, there is existence. Okay, or the quality of the goods or services. So the dispute can be related to quality of goods. So I am asking you to provide A category services, but you are providing B category services or B category goods. Okay, so quality is different. Then the breach of representations or warranty. Suppose when corporate debtor is selling the goods, when opposite person is selling the goods, okay, so he must have made certain statements. If there is any breach of representation or warranty is there, then in such cases corporate debtor can raise these issues. Okay, so when you are selling the product, you have stated that the product will have ABCD characteristics, but ABCD characteristics are missing. Okay, then you can raise a dispute as to the quality of the goods. Okay, then what is the meaning of pre-existence? Okay, because if there is any pre-existence disputes are there, you cannot file a case, you cannot make an application. Then what is the relevant date for determining the pre-existence, when it is considered to be pre-existence? Okay, the dispute must exist prior to the notice under section 8. So when I am using the word pre-existence, it does not mean that when you are giving the notice immediately I am stating that there is a dispute is there. I cannot say like that. Okay, the dispute must exist before or prior to the notice under section 8. Okay, before operational creditor gives the notice to us, notice to the corporate debtor, the corporate debtor must have raised. Okay, the dispute must be there before that. Then if a dispute is raised for the first time in response to the section 8, then please remember that cannot be considered as a dispute, because there should be dispute, that is pre-existence dispute. Pre-existence dispute means today if I am giving notice to you, already the dispute must be in place. Okay, so when I am giving the notice today and you are saying that there is a dispute is there, you remembered now, then that is not considered to be dispute. Okay, so already existing dispute must be there. That is the meaning of pre-existing dispute. In the case of Mobilox Innovations Private Limited, it was held that, okay, the dispute in the case of Mobilox Innovations Private Limited, the Supreme Court held that the dispute must have raised before the issue of notice. So that means you should have raised a dispute before issue of the notice itself. Once the notice is issued, you cannot raise a dispute now. Okay. Then suppose you fail to reply to the notice. Operational creditor gave notice to the corporate debtor. Corporate debtor fails to reply. Then in such cases, what happens? Okay. So mere non-responding to the notice under section 8, does it entitle corporate debtor, that is CD, from raising the defense of pre-existing dispute? So when operational creditor is giving notice to the corporate debtor is having an option to raise a dispute immediately. I mean, stating that already existing dispute is there. There is another possibility, corporate debtor maybe he has not replied. Okay, operational debtor already filed the case. Then do you have an option to raise the point of pre-existing dispute during the proceedings? Yes. During the proceedings also, you can raise the dispute, or you can raise the point that already pre-existing dispute is there. Okay. So mere non-responding to the notice under section 8 does not disentitle, it will not give away, it will not take away your right to represent before the court of law. Okay. So where the decree award is challenged in an appeal, is it a dispute or not? Suppose take the example. Okay, so I am saying that corporate debtor is liable to pay so and so amount. Okay, so I file a case. Imagine I am the operational creditor. I file a case for the court of law. Then the court of law gave the order stating that I am entitled to receive the payment. But it was challenged before the court of law, appellate court, by the corporate debtor. So whether is it considered to be disputed decree? So NCLAT in the case of Pragat Akshay Urja Limited versus Madhya Pradesh Urja Vikas Limited. So in this case, it was held that whenever there is a pendency of the case is there, so then that is considered to be existence of the dispute. So you cannot file the case when there is any cases pending before the appellate tribunal. Suppose take the example, there is a arbitration clause is there. So the corporate debtor, operational creditor, they have entered into an agreement where in the agreement arbitration clause is there. So if an arbitration clause is there, so or can you file an application under this section? NCLAT in the case of Milton Consultancy and Engineering Services Limited versus Vittal Corporation Limited. So in this case, it was held that mere existence of arbitration clause between the parties would not bar an application under section 9. So merely because you are having arbitration clause, it does not mean that I cannot file a case under section 9. So even if you are having arbitration clause, then you can file a case. But look at the next case law. Parmod Yadav versus Divine Infracon Private Limited. So in this case, NCLAT, National Company Law Appellate Tribunal, if arbitration clause been acted upon by giving the notice in terms of section 21. So that means arbitration clause is there. You have already started the process of arbitration. You have already issued the notice under the Arbitration Act. That is section 21 of the Arbitration Conciliation Act. Then in such cases that amounts to existence of dispute, you cannot file a case or you cannot make an application under this section. So same would be existence of dispute. So if there is any arbitration clause is there, only clause is there, that is not existence of dispute. Clause is there, opposite person has already issued the notice. Then in such cases, it is considered to be existing dispute. Now, whether pendency of criminal proceedings, will it constitute pre-existing disputes? In the case of Totappa Nayanar Muhammad Sirajddin versus Intex Technologies India Limited. In this case, NCLAT held that if any criminal proceedings are there which do not fall or which did not constitute pre-existing dispute, because we are considering, because it's a IBC is a civil legislation, we are considering only civil disputes. We don't consider the criminal disputes. So mere filing of an application for reference under section 17 and 18 of MSME Act. Suppose under section 17 and 18, someone has to, one of the vendor is supposed to pay the money. He failed to make the payment. Then there is a possibility you can refer the matter to MSME board. So if you are referring the matter to MSME, then you cannot file a case under section 1 under this act. IBC. In the case of I Value Advisors Private Limited versus Srinagar Banihal Enterprises Expressway Limited. In the case of I Value Advisors Private Limited versus Srinagar Banihal Expressway Limited. In this case, NCLAT held that pendency of civil court for recovery of the money is a pre-existing dispute. So whenever there is a case is pending before the court of law for the recovery of the money, such dispute is considered to be existing dispute. So even it was supported by the NCLAT, reiterated by the NCLAT in the case of Landmark Realty versus Siroya Developers Private Limited. So dispute raised via email, will it be sufficient or not? So before receiving the notice, the corporate debtor is supposed to give the reply stating that there is a dispute is there. Suppose corporate debtor raised the dispute, raised an objection through email, will it be accepted? So in the case of Krishna High-Tech Infrastructure Private Limited versus Bengal Shelter Housing Development Limited, NCLAT held that the mere mail, so merely through mail, if you are informing the opposite person that there is a dispute is there, then in such cases it is a valid ground. It is considered to be pre-existing dispute. Now, suppose proceedings under section 138 of the Negotiable Instrument Act. There are check bounce cases are there, proceedings against are there. So will it be considered to be pre-existing dispute? It was held that it is considered to be pre-existing dispute. So there is a case law, AD Electro Steel Company Private Limited versus Anil Steels. In this case law, the Supreme Court held that section 138, if there is any cases there, so it will not bar the provisions under IBC. So still you can parallelly continue the IBC. Then any pendency of civil suit for recovery of money, is it a pre-existing dispute? There is a question mark. So in the case of Landmark Reality versus Siroya Developers Private Limited, it was held that, okay, if there is any pendency of civil court is there for the recovery of the money, then, okay, so it is considered to be existing dispute. Now, let us look at the application under section 9 of the IBC. So, in form number 5. In form number 4, already we have discussed how to give the demand notice. Okay, in form number 5, we are going to look at how to make an application to the NCLT. Okay, either NCLT or NCLAT as a case. Yeah, this is form number 5. Okay, so please look at the screen. Application by operational creditor to initiate CIRP process under chapter 2 of part 2, under chapter 4 of part 2 of the code. Okay, so here you are going to give two address. So here you are going to give the two address. Okay, then from where you are supposed to give the address. Then name of the operational creditor. So whoever is making an application, his name. Identification number of the operational creditor. If any identification numbers are there, please give the data. Okay, then address for correspondence. So you are giving the name, address, then identification. Okay, so these three things. Then part 2, particulars of corporate debtor. So here you are going to explain more about corporate debtor. Okay, so what you are going to explain? Name of the corporate debtor and identification number of corporate debtor. So each and every corporate debtor will have the identification number. Okay, so identification number. Debt of corporation, date of corporation or corporation debtor. So nominal share capital and the paid up share capital, address of the register office of the corporate debtor. So these are all the basic details. Okay, so names, address, authority, name and address of the person resident in India. Okay, so the details of the corporate debtor as per the notification. So these are all the basic information to be given along with the application. Okay, so part 3 is also there. Particulars of the proposed interim resolution professional. So as already I told you, whenever you are making an application under this section, you are supposed to give the information as to the solvency professional. Okay, then particulars of the operational debt, total amount of the debt, details of the transaction and account of which debt is field due. So basic data. Okay, then particulars of the operational debt, that is documents, records and evidence, default. So any other information that is there available with you, you can give this information here. Okay, then you are going to give the declaration. Okay, so this is how you are going to make an application in form number 5. You are clear with the concept of application under section 9 of the IBC. Okay, then joint application. Whether joint application can be made, unlike in the financial creditor. In case of financial creditor, there is a possibility you can make the joint application. But in case of OC, operational creditor, he cannot make joint application. Okay, so NCLAT in the case of Yuvraj Agarwal versus Aspect Media Private Limited. In this case, it was held that the notice is to be delivered individually and application to be made individually. So whenever you are making an application, you are expected to have the triggering point. Okay, as already we have discussed, minimum 1 crore default is considered to be triggered. So you are expected to have that. Okay, so who can exercise the jurisdiction? In the case of Mobilax, the Supreme Court commented that, okay, so whether there is an operational debt as defined exceeding the amount. So whenever you are accepting or whenever you are exercising the jurisdiction under this law, you have to consider these points. Okay, whether there is an operational debt or not. So you have to go to the operational debt definition. Okay, so whether there is a operational debt or not. Next question, whether the documentary evidence furnished with the application shows that the aforesaid debt is due and payable and has not been paid. So the documentary evidences, we need to have documentary evidences stating that the operational creditor has not received the money. Okay, so this point you have to remember. Then whether there is existence of dispute between the parties. Okay, so first of all, there should be operational debt. Then there should be evidence stating that I am supposed to pay the money. Third point, whether there is existence of dispute. Is there any dispute between me and you? Okay, you and me. So parties between the parties, or the records of the pendency of the suit, if any suit is pending before the court of law. Okay, so our arbitration proceedings. Then these things you are supposed to verify before exercising the jurisdiction in these scenarios. Okay, then distinction in treatment of financial creditor and operational creditor. So there is a distinction is there between the operational creditor and financial creditor. Both are not treated equally. Okay, so if you observe the definition, who is OC? An OC is a person to whom an operational debt is owed. Who is FC? FC is a person to whom financial debt is owed. What is the nature? The debt arises from the provision of goods or services, whereas In case of financial creditor, the debt arises from the borrowing or lending. So either it can be borrowing or lending. It's not day-to-day activities. Okay. Then initiation of process. Initiation initiates insolvency under Section 9 of the Act. Okay. Whereas section initiates insolvency under Section 7 based on the default. Okay. So here default is very, very important. Then types of creditors. So operational creditors typically involve trade creditors, service providers, and suppliers. Financial creditors includes banks, financial institutions, and other institutions. Okay, so whatever it is, everyone is included. Then claim type. Operational claims are related to day-to-day business of the transaction. Okay, whereas financial creditors, the financial claims generally involve principal and interest on loans and other financial instruments. Okay, so possibilities is some other financial instruments must have been issued. Okay, then resolution process. OC is generally required to proof of default. Okay, so OC is supposed to, operational creditor is supposed to submit the proof of evidence stating that so and so person is liable to make the payment. FC can initiate with evidence of default. So FC need not to show anything. Okay, just he has to show that there is a default is there. Okay, there is a evidence is there. Okay, that is more than sufficient. Then role of resolution. In case of operational creditor, okay, OC may file claim but do not participate in COC meetings and decision making process. So are you going to participate in the decision making process? No, I'm not going to participate in the decision making process in the case of operational creditor. In case of financial creditor, so obviously he is a center person, he is a core person. So financial creditors play a central role in the COC. Okay, so influencing the resolution plan, its approvals, etc., etc. Okay, so he's a person, he is one of the person who can influence the board of directors. Okay, then voting rights. Whether operational creditors, will they have any voting rights? No, they don't have any voting rights. Okay, then financial creditor will have the voting rights. Okay, in the committee of the creditors and influence. Okay, so influence the resolution professional. Okay, so he can exercise the voting rights only to influence. That's it. Other than that, he cannot exercise the rights. Okay. So with this, we have completed application to be made by the operational creditor. Okay, so let us look at the application, how you are going to make an application. Okay, this is the application you are going to use. Form number 5. Okay, form number 5A to be issued in the letterhead of bank. Okay, so because we are attaching the evidences, the evidence can be attached in this form. Okay, let us recap what we have discussed today. In today's session, we have discussed about the initiation of CIRP. So in the initiation of CIRP, who can initiate the CIRP? Then we have discussed that CIRP can be initiated by operational creditor, where we have discussed section 8 in detail. Then application for initiation of corporate insolvency resolution process by a corporate debtor. That is, the process is discussed under section 9 of the IBC. We have discussed the process also. Then please remember, whenever if you want to make an application, file an application under section 9, then you are expected to give the notice under section 8. So issuing the notice under section 8 is mandatory to file an application under section 9. The provisions relating to section 8 and section 9 we have discussed in this class. Then reply to section 8. So when a notice is served under section 8, how to give the reply to the notice given under section 8 we have discussed. Then subsequent to that, we have discussed the concept of pre-existence of dispute. So whenever there is a dispute is there, then in such cases, operational creditor cannot initiate the CIRP under section 9. So what is the meaning of pre-existence of dispute we have discussed. Then in case of any arbitration clauses existing between the parties, then how to deal with that scenario we have discussed. Then we have discussed the concept of application under section 9, that is form 5. Practically we have seen the form also, how to make an application. Then is there any possibility of joint application by the operational creditors? We have discussed. Then subsequent to that, we have discussed the comparison between financial creditor and operational creditor. So in terms of application and in terms of notice, okay, various criteria we have discussed. Okay, the difference between financial creditor and operational creditor. Thank you.